Welcome, everybody. Thanks very much for coming. This is a joint production, I guess, of the Center for Business Law and Regulation and the Federalist Society. So I'm wondering, is there anybody here, since I'm representing the Center, is anybody here representing the Federalist Society? If you would like to come down and say a few words, welcoming you, or just sit there and welcome everybody, that would be fun.
I'm not sure if I prepared for this, but thank you everyone for coming. Now I'd like to turn it over.
So we're very federal in our views, which is, we don't actually coordinate before. So I'm very, very pleased to introduce Henry Butler, who I found you were actually the first executive director of the Searle Center at Northwestern University School of Law, and a senior lecturer as well. And I know him from the book that I guess you're co-author of, the Sarbanes-Oxley Debate, What We've Learned, and of course, How to Fix It, which seems fairly similar to the topic of today's presentation. And you had so many great jobs in the past, I don't know if I should read through them all. James Farley, Professor of Economics at the Business School, and also the Professor at the Business School and of Economics, and a law professor all at Chapman. Just to think of the number of the committees you had to serve on. It's pretty amazing. And before that, you were a distinguished professor of law and economics at the University of Kansas, where I gather you were commuting from Kansas to California. Is that right? For a little while. Showing what a dedicated academic you were. Before that, you were a professor at George Mason, and you were also an Olin Fellow at the University of Chicago Law School. And you've got a Ph.D. in economics from Virginia Tech, and also a J.D. from the University of Miami. And so you have more degrees than a thermometer and more impressive teaching appointments than I ever will have. So I'm definitely going to stop speaking and turn it over to you.
Thank you very much, Richard. It's a pleasure to be here. Sorry Jonathan Adler couldn't be with us tonight. He's the person who extended the invitation to me on behalf of the Center. And I welcome the opportunity to talk about Sarbanes-Oxley. This is material tonight is based on mostly out of the book that I co-authored with Larry Ripstein, who's a professor at the University of Illinois. We were colleagues at George Mason many years ago, and had the opportunity to get back together and work on this book entitled The Sarbanes-Oxley Debacle, which kind of gives you a hint about where I'm coming from on Sarbanes-Oxley. It's been a great bestseller, New York Times, #1 for a couple of years now. If you're buying that, I got some stock for you, okay? Now, the question, the one way to think about SOX is if you read the Act, it actually starts off as the preamble is it's an act to protect investors. And one of the questions that we raise in the book is whether or not Sarbanes-Oxley actually protects the people it's alleging or claiming to protect. But underlying that is the basic question of how much protection do shareholders want. One of the reasons people get a nice return on equity investments is because it's riskier than some other investments that are out there. The more protection you get, the less risk you have. The less risk you have, the less return you'll get. As shareholders, most people with diversified portfolios are experts at taking on that risk. So how much of that risk do you want to have taken away from you? And so we address this kind of from the perspective of marginal benefits versus marginal costs. What protections are you willing to pay for, and what are the costs associated with those? And a kind of a fundamental economic point that we make at the start of the book is that the optimal amount of fraud, and I'm not here to defend fraud, but fraud is something that is expensive to get rid of, and it can be a problem in every organization. That the optimal amount of fraud, malfeasance, accounting mistakes is not zero. Okay? Perfection is the enemy of the good, and it's not something that shareholders really want. So that's kind of a fundamental point that arises every now and then, but a lot of public policy debates about issues talk us in terms of absolutes. Well, this is one where, in the financial world, we don't want these absolutes. You don't want to pay for it. It's the same way with your car. All of you could probably, I guess, find a car that is safer than the one that you're currently driving. But you're not willing to pay for it. You're making that trade-off. Well, the same way with the stocks that you have. How much safety do you want? One of the other points we make in the book is a difference between accounting cost and economic cost. And I'm going to come back to this in a little bit, but I just wanted to... accountants are very good at adding up hard numbers when they've got them. But economists see costs a different way many times. And one of them is what we refer to as opportunity cost. What could you have been doing with your time instead of complying with Sarbanes-Oxley? And it's very difficult to measure that. But just to give you an example, if someone's trying to tell you that the cost, you say you've got an executive who's paid $1 million a year, and the executive's spending a quarter of his time complying with Sarbanes-Oxley. An accountant would say, well, it costs $250,000 a year of that executive's salary to comply with Sarbanes-Oxley. But the company and shareholders are willing to pay that executive $1 million a year because the executive is worth more than $1 million a year. Or say $2 million a year. If you take away a quarter of the time, then maybe it's $500,000 in opportunity cost that's there. So there's a big fundamental difference between accounting numbers and economic costs that I'll bring up again in a minute. Okay. SOX myths. SOX improve investor confidence. You hear that again and again. For a while I used to have up here a quote from what I would call the politically correct CEO. When SOX was first passed, it passed an almost unanimous vote through Congress and the Senate, which should scare you right there. But when it was first passed, the business community was really kind of shell-shocked by what was going on, and no one was criticizing it. Tom Donahue, the president of the U.S. Chamber, which generally represents the interest of small business, was one of the early critics. So was Hank Greenberg, which made him a big target for Eliot Spitzer, which kind of sent a message out that perhaps you shouldn't be criticizing Sarbanes-Oxley. But the notion of it improving investor confidence is one that is insisted upon by SOX proponents. And one of the things they point to is the incredible bull market that we've had. But that bull market didn't start the day SOX was passed. Right? There's no statistical evidence demonstrating that bull market occurred because of SOX. In fact, I think a stronger case can be made that the bull market occurred in spite of SOX. Another thing, SOX improved business practices. You hear a lot of this, especially from accountants who are making a lot of money on this aspect. But I'm a free market kind of guy. Right? And I'm very skeptical of that. For the U.S. Congress to actually do a better job of running a business than business people can, it reminds me of Ronald Reagan's famous statement, the 10 most dangerous words in the English language. Hi, I'm from the government and I'm here to help. Okay? This, it's kind of on its face, and it just seems to be ludicrous. The next one is one that, as people could argue with me about. So the costs of SOX are declining, and they clearly are in the sense of there were some heavy fixed costs that firms incurred to get geared up to put in the compliance systems to deal with SOX. And those fixed costs have gone down, and so the annual costs of complying are less than they were before. But those are the accounting costs, and I think there are a lot of other costs I'm going to talk about later on that are still there and are looming over American business. And it's not clear to me why they should have gone down at all. And that those costs, which are probably more important than the accounting dollars, are still there. So I'm going to come back to that point. Okay. I'm going to walk through, this is kind of the outline of the next points I'm going to be making, that SOX does not benefit shareholders. And go through all of these points in more detail. Don't put all your eggs in one basket. One bad apple can spoil the whole bunch. Y'all heard these things before, right? Okay. If it ain't broke, don't fix it. Everything worth doing is not necessarily worth doing well. Maybe not have heard that one before. Okay, don't put all your eggs in one basket. As I mentioned earlier, shareholders are specialists at bearing risk. They hold diversified portfolios. The risk of having fraud or malfeasance within the company is very similar to other types of business risks that can be taken on that a company can deal with. It is firm specific. It can be diversified. It can be part of the portfolio, and shareholders can handle it. They're experts at dealing with risk. SOX, by requiring all companies basically to go through the same internal control expenditures and the same type of expenditures, takes away part of that risk. Now, it may be good to take away that risk, but if the risk can be borne more cheaply by the shareholders as opposed to requiring the money to be spent, it's not a good job for shareholders. One of the concerns about this is that the defendants, meaning corporate executives, board members, can't diversify that risk the same way that shareholders can by making them criminally liable, civilly liable. It may lead to some risk aversion on their part and negate some of the benefits that we have of a public stock market. One bad apple can spoil the whole bunch. Well, we had more than one, but Enron, WorldCom, Adelphia, you can go on down the list of the major scandals that we had in 2001. They screwed up the market. They screwed it up in a number of ways. But you've got to remember the stock market was on its way down before most of these things became a problem, that we were in a correction in the market before this happened. So it didn't necessarily screw up the market, but it did screw up governance of corporations, because when you have disasters, Congress acts. And so what did we do? We had the Sarbanes-Oxley passed. An alternative is, when you catch the bad apples, punish them, send a message. And guess what? We had all the laws on the book you could possibly need to take care of those folks who misbehave. There are people in jail now, people who've had to pay large amounts of their personal wealth as a result of prosecutions based on Enron, WorldCom, and those laws were on the books before the passage of Sarbanes-Oxley. We had lots of weapons out there. There was punishment, there was deterrence, and I think the way I like to think about some things is that it was kind of like a pendulum. During bull markets, people relax, oftentimes relax, on the corporate governance matters, other control matters. Things are good, the company's going well. They may not pay as much attention. And boom, when the market goes down, things tighten up. There's a friend of mine says, when the bull market's in, people go to jail. And so we go through these swings. My guess is we can go through them again. Another point to make is, if it ain't broke, don't fix it. Prior to Enron, our corporate governance system was viewed as the envy of the world, the best system around. And but after Enron, that view kind of evaporated very quickly. There were lots of attacks on our corporate governance system, and I would argue that the system actually responded very well. We had people who were on boards of these companies that had all the major scandals, aren't on boards of companies anymore. They've been punished. People have been fired. Careers have been ruined because of their behavior, because of their misbehavior. We had a lot of punishment going on before Sarbanes-Oxley was passed. And the corporate governance community woke up during this time period. Before SOX was passed, there was all of a sudden a flurry of activity, of training programs for directors, discussions about people moving off of boards, of having smaller boards, of having people not serve on as many boards. Lots of things like that were going on after that, and we were working our way through the process. And I would argue the system was well on its way to self-correction before Sarbanes-Oxley came along. Given that, if I'm correct about that, and the system was already moving forward and correcting itself, then on the margin, there wasn't a whole lot of room left for Sarbanes-Oxley to improve things. Now, you could say, well, Sarbanes-Oxley does all these wonderful things. And I said, well, that would be great if we started from ground zero and we added Sarbanes-Oxley. Maybe if you were going to build a corporate governance system from scratch, you could start off and put Sarbanes-Oxley in. But it's not like that. I mean, to give you an example that you're all familiar with, most cars have 3 taillights on them. When I was growing up, they used to have 2. And if you look at that and look at the car and you say, well, there's a third one there, the value of the third tail light, wherever it's located, is not worth as much as the first tail light. Okay, so the analogy I would draw for you is that we had 2 tail lights on the car. Okay, maybe the bulbs had gone out, all right, and we had the messes of Enron and WorldCom. But after those the crashes of Enron and WorldCom, the bulbs were replaced. Things were back on. And then to come along and add another tail light, well, that's maybe has some value. but it costs something. I would argue that Sarbanes-Oxley not only had the third, but probably the fourth, fifth, sixth, seventh, eighth, ninth tail lights in the back of the car. And you can understand, if you get so many tail lights on the back of the car, it could actually be a safety problem, right? You could blind the people behind them, and they crash. So that's maybe bad. I'm just making this up as I go along. I mean, what am I smoking, right? Okay. How does a well-functioning system allow Enron or WorldCom to occur? I mean, I've got to be crazy to stand up here and say the system was functioning well. Well, this is what economists call the nirvana fallacy. We have an imperfect system before, and now we've replaced it with a perfect system. Anyone who thinks that we have a perfect system now is the ones that are smoking something. We've had lots of instances of fraud since Sarbanes-Oxley was passed. We have not gotten rid of all fraud. And I'm confident that with Sarbanes-Oxley in place, or without it, that we're going to go through another crashing of companies similar to what we had with Enron and WorldCom. The regulation is just not that good. Now, it may not happen in this next downturn we have in the stock market, but give it 10 years. We're going to forget about what happened. We're going to have a new generation of managers. Things are going to get loosey-goosey again, and we're going to have the problems. If it actually is broken, find someone who knows what they're doing to fix it. I've spent a lot of my professional career writing on corporate governance and the competition between the states, which Delaware has been leading for 100 years, or almost 100 years, and trying to understand that phenomenon, what has gone on with that. A professor at Yale, Roberta Romano, a few years ago wrote a book entitled The Genius of American Corporate Law. And part of her story was that this competition between the states has resulted in experimentation and gradual improvement and adaptation of our corporate law to meet the needs, changing needs of business over time. And that is really, that federalist system has been a great source of strength for us. Over time, we have avoided a number of efforts to have the federal government come in and take over the state system. In the 70s, there were proposals for federal chartering of large corporations. We've had the encroachment of federal securities laws into internal corporate governance issues, which have traditionally been left to the states. And there have kind of been a traditional dividing line there. It had kind of stayed there pretty firmly, and surprisingly, it's from some political pressure. Well, the regulatory panic after Sarbanes-Oxley kind of shot right through that. Instead of the long, slow discussion, measured process that typically goes on in the evolution of laws through the state, we had an emergency, and Congress had to fix it. Now, this may be, the proverbial camel's nose under the tent in terms of the feds getting into some of this stuff, or it may just be a little foray. But we had the federal government we've got now independent audit committees mandated by the federal government. We've got non-audit services regulated by the feds. We've got controls over something as mundane as executive loans, limitations on that. And by the way, executive loans are traditionally a very valuable thing for corporations. I mean, I just moved from California. If you're moving from Kansas to California and you want an executive to take a job in California, you need to help them buy a house out there. All right? Because houses cost 10 times more in California. Okay, I'm with 5 times more. Another thing, executive certification of financial statements. Whenever I say that, well, that's a bad thing, people look at me, why is that a bad thing? Don't you think executives should have to certify this stuff? And I said, well, yeah, but within reason. All right? And the problem that I have with executive certification of financial statements is not that they are going to certify it, is that how much time they're going to spend taking to certify. That if they're threatened with going to jail if they sign a document certifying something that's true and it's not true, then they're going to spend an awful lot of time doing that. And they could be, for me as a shareholder, they could be making a lot more money instead of worried about that. So those are things that it would be nice to see evolve in the states, it seems to me, as evolved through as being imposed through the feds. The nice thing about state competition is that over the years, if a state makes a mistake, then firms that don't like it can opt out of that law by reincorporating in another state. The problems with Sarbanes-Oxley and the feds getting involved in internal corporate governance is that if they make a mistake, where are you going to reincorporate? All right, so we've kind of got that dominant state. But, and one of the surprises to me, and I'm sure to my co-author, has been the extent to which international capital markets have responded to Sarbanes-Oxley. We now have, this past year has seen 3 major studies of the impact of Sarbanes-Oxley on the attractiveness of U.S. capital markets. It's new firms, new IPOs going overseas instead of being in the U.S. markets. Hillary Clinton and Chuck Schumer being concerned about excessive litigation scaring companies out of the U.S. They've never shown this kind of concern before, but when it affects New York City, they start to worry about it. And so we've had these studies. That competition is markets in action. And it is a way to perhaps force the U.S. to rethink where we are on some of these laws, and I'm sure it is. We haven't really moved back a lot on things, but there's the potential there. But maybe we're still close to the events that triggered it. But anyway, the concern here is that we've hurt our capital markets, and that cost is very obvious now. And so let's get on with perhaps improving things. Now, you know, this is one of the problems with PowerPoint. Somehow this thing is set up so it doesn't go through this, and I can't give you my punchline here. See, Sarbanes-Oxley did not mess with the thing that almost always, what most people would talk about when they're concerned about corporate governance, is executives getting paid too much. And the good thing I can say about Sarbanes-Oxley is it didn't mess with executive compensation. But I can't, for some reason, I have this not set up right on. Okay. Cost of Sarbanes-Oxley. The costs you hear the most about are the direct compliance costs. I'm going to run through a list of those. But I think the bigger and more larger costs we can be concerned about are the opportunity costs, which I'll explain in a second. And then another thing that Rich and I talk about in the book entitled The Litigation Time Bomb that's going to go off one of these days. Direct compliance costs. Y'all can read this list. Okay? The main point I want to make with this is that when Sarbanes-Oxley was passed, and like all good legislators, they engage in a cost-benefit analysis. And they try to compare what are the costs of the legislation with the benefits of the legislation. And assuming that they went through that process and they decided that the benefits were greater than the cost, hey, that's what they're supposed to do as policymakers. And they're supposed to make those trade-offs. Well, as it turns out, that the costs of Sarbanes-Oxley, the direct costs, have been so much higher than was ever estimated. The SEC had estimated compliance with Section 404 was going to be, something absurd, like numbers of hours, not days, but man-hours that they came up with that ended up being way off by years. Okay, so they went from hours to years. All right, when you're that far off, that should give you, as a policymaker, pause. Okay, about did I really get this right? So there've been some big misses there. I moved here moved to Chicago from California recently, and a company in Orange County where I lived in Cyprus is Universal Electronics, and it's actually a pretty cool company for all of us people who like to surf channels, right? Because they're the folks that make the universal remotes. Okay, they've got the technology that allows you to control the VCR and the TV and all your other stereo all with one piece of equipment, if you can figure out how to use it. So they're the ones with that technology. All right, and their ownership is fairly concentrated, but they're publicly traded. In 2004, look at these numbers. Net sales of about $160 million, net income of $9.1 million, which would have been, but for SOX, $11.4 million. Okay? This is a big chunk of their profits that they went towards doing something. Now, with all due respect to our friends in Congress who passed this law, if there were fraud in Universal Electronics, do you think that would cause any major shakeup in the stock market, like Enron and WorldCom did? These are not the targets, but these are the folks that are bearing the cost. Okay? And small companies all around the country were having to comply with this and spend all this money. And they're just not the ones that are likely to cause another mess in the stock market. Opportunity cost of SOX. Distraction and diversion of leaders. Everyone in the corporation, anyone who works for a large corporation, has been dealing with Sarbanes-Oxley from the top to the bottom, with the internal controls and trying to get it to work, with all the compliance, with the cost, with the auditors bullying them around. All of this has gone on and taken up a lot of their time. And you've got the board that's focused on compliance issues as opposed to strategic issues. You've got firms exiting the stock market. You've got private equity buying public firms and taking them out of circulation. We've got boards that are afraid to take on risky projects. There's criminal sanctions that scare people. I mean, one of the typical academic discussion of the corporation is along the following lines: the separation of ownership and control. I know many of you are taking business associations now. The Burley and Means story about the separation of ownership and control, concern that executives have hijacked control of the company. They're basically deciding who gets to be on the board, so they're picking the people that are supposed to monitor them, and they can do whatever they want to do. And we call that agency costs. And there's a whole economic literature that responds to that story, talking about market mechanisms, contractual mechanisms designed to try to solve those agency cost problems. But I can tell you one place: if I'm an executive of a company and someone says, you know, if you don't get this right, they tell me, Henry, if you don't get this right, you might go to jail. There's no amount of the corporate resources I'm not willing to spend in order to make sure I don't go to jail. All right. Now, it may not be in the best interest of the shareholder, but it's in my best interest, and guess what? That's where the rubber hits the road. I don't want to go to jail. All right. And I think that what we see here is that very risk-averse executives saying, we got to get this right. There's criminal sanctions out there. I don't want to wait around to the courts to figure out exactly what they mean until some ambitious U.S. attorney decides to come put me in jail. No, let's go get it. Let's spend the money. And of course, the waste of conferences and programs on SOX. Now, you've all heard about the big problems for small firms, and this is kind of a classic thing with all regulation. That the larger firms basically have some economies of scale in dealing with compliance with regulations, so there's an unequal burden on smaller firms. And that you can say that about all types of regulations. And it's been a particularly small problem for small firms with SOX, and it's been well documented, and there have been some exemptions and some extensions for small firms. There are a number of points that have been made there that are mentioned there. I guess when I hear this, I'm saying, well, I'm kind of torn about what should be done about this, because the small firms, entrepreneurial small firms are kind of a sacrosanct entity in Washington, and the National Federation of Independent Business and the U.S. Chamber, they carry a lot of weight to protect these folks. And one of the temptations, I'm sure, in Congress is, well, let's just exempt all the small firms from this. But I think, frankly, that we're better off to say, tie them all together and sink or swim. That if we can find a way to maintain a political coalition to try to get this undone, we'd all be better off. Now, that's probably dreaming, but there is a divide between the big firms and the small firms about who cares about this. Turning business people into criminals, I've already kind of talked about that. The litigation time bomb. We've talked about this certification of internal controls. Here's the basic story. SOX requires corporations to develop internal controls to deal with a whole host of activities. The process of developing internal controls is an incredibly document-intensive process where there's, and that's a lot of what SOX requires, is documentation of what you've gone through, put your controls in, what you've done to test your controls, to make sure that your controls are working. And in the process of that, you may find out that your controls are deficient in some areas and that you need to correct them. And you have to make decisions about whether or not it's a material deficiency that needs a lot of attention or doesn't need a lot of attention. But a lot of resources go into doing this. The concern that we're talking about here is that eventually when we have a decline in the stock market, a major decline in the stock market, there are going to be lots of companies whose stock goes down, which is creates an opportunity for aggressive attorneys to file lawsuits alleging that the stock has gone down because of some deficiency in the internal controls. If they can get to the stage where they get a judge to order discovery of all the documents associated with the creation, the testing, auditing of the internal controls, somewhere in there they're going to find kind of a magic smoking gun that says, this is why your stock fell down. And the claim is going to be tried to tie it back in and say, you had deficiencies in your internal control, the documents indicate you knew about them, pony up, put the big bucks on the table. Right? And that's a recipe for a lot of litigation. That's the time bomb that we're talking about. Now, the SEC has tried to take some steps to try to alleviate some of these concerns, but my guess is that most corporations don't worry. They don't take a whole lot of waiting for that. They're waiting to see what happens once the litigation starts to occur. But this type of thing casts a shadow over a lot of corporate decision making because they're aware of this concern hanging out there on top of it. Okay, so where are we on this? Let me do my version of the cost-benefit analysis of SOX. The first part of my talk was to try to convince you that SOX couldn't really add a whole lot of value, a whole lot of benefit, because we already had a really good system. We already had the light bulbs had been replaced, right? So we were already, the potential benefit is not that huge. And then there are tremendous costs that are paid by corporations to comply with that. Now, a lot of people like to look at that and say, well, it's just corporations. Well, corporations never pay taxes. Okay? Individuals pay taxes. Shareholders pay taxes as individuals. And Milton Friedman, this is one of the many things he's famous for. Only people pay taxes. There is nothing free about this. There is no free lunch with SOX. It's been incredibly costly to us. So the bottom line I have on this is that SOX is a bad deal for the people it's supposed to be protecting. What do? Well, obviously I think it'd be nice to repeal the sucker, the entire thing. But, I got to have a touch of reality in my presentation, so that's not going to occur. But I think there are some things that could be done. We could eliminate the civil liabilities. We could get rid of criminal penalties. We could just basically have the SEC enforce these things in ways that perhaps don't have the same bite they do. We could exempt small firms. We could exempt foreign firms. But I think the one that I like the most of all this is just to have a contracting model, an opt-in or opt-out. If a company, through a shareholder vote to no longer be covered by Sarbanes-Oxley, let them do it. Let that be a shareholder proposal that would be voted on. And you can make it supermajority if you want to. My bet is that the first company that did that is going to see its stock price jump up. Okay? As soon as it announces it's going to have a vote on the stock price jump up. Right? And that we would have a lot of other companies who would follow suit if that occurred. But whether we'll get there or not, I don't know. But the last time, well, not the last time, we've had a lot of these things, but that's enough for me to talk about it. So that's all I have to say about Sarbanes-Oxley. I'd be happy to answer your questions, deal with your criticisms, and I've got a lot of John McCain in me, If you heard how he responded to some question the other day. So. No, I'm just teasing. Yes, fire away.
I'll start off, Henry, and it's difficult for me to take issue with you here because I'm no fan of Sarbanes-Oxley. I guess to the extent that I'm bothered by what you said, it's this. Two related things. One is you mentioned that the American corporate governance system is the envy of the world. And certainly that was true a while. I don't know if that's so true anymore. I think a lot of other countries have improved their corporate governance laws, and I think in many cases now, sophisticated institutional investors feel that they get treated better in other countries, that in particular CEO domination here is worse than it is in other countries. Now that doesn't necessarily go much to, I mean, obviously SOX doesn't, the problem I'm describing, if it is a problem, is not addressed by SOX. But I did want to take issue with that. The other is you mentioned.
Can I just respond to that now?
Well, why don't you let me finish my because it's kind of somewhat related. The other is you mentioned the Nirvana fallacy, that if there is if the market in some respect is discerned not to be perfect and frictionless, which of course it is, then the solution is government regulation. You're right.
Perfect and frictionless government regulation.
Assume that's always the solution. But we also, I think, need to be careful about assuming that the market is perfect and frictionless when it comes to corporate governance. And here again, I think that's simply not an accurate assumption. There are a lot of inefficiencies there. You mentioned going private. Certainly you're right. One reason for the going private trend is to avoid costs of Sarbanes-Oxley. But that's only one of many reasons, and probably if anything, the bigger reason is that you now have a situation in which shareholders tend to be, if not powerless, at least having to share a lot of power with CEOs who are able to divert a lot of resources to themselves. And one reason for going private transactions is you then will substitute a diverse group of public shareholders who have a collective action problem with Goldberg, Kravis, and Roberts. They're not going to be so easily fooled. They're not going to be so easily played around with by a CEO as the scattered shareholders. So I guess what I'm bothered by is some implications of what you said, that our corporate governance system would be hunky-dory if the darn government just stayed out.
Well, I very much appreciate your comments on that, and response to the first one about our kind of international competitiveness of our corporate governance system. I think it's fair to say that over the years, even before Enron, WorldCom exposed a lot of our problems, that we were not perfect, and that the world markets for capital were becoming much more competitive with other players entering into the market, and that we had our absolute advantage that we had over other competitors was shrinking, and because they were trying to adopt their corporate governance systems and try to not out-Delaware us, but to try to come up with alternative models that would be better than the system that we have in the U.S. And one of the things that a lot of other countries have done is try to cut down on private lawsuits relative to what we have. And there's a lot of arguments that we were losing our edge, and that as Sarbanes-Oxley gets into the thing, it kind of took us over the margin. And now we are not the best in the world, in the sense that, or certainly our competitive position has been diminished. But I totally agree with your bigger point that our dominance is not something that we can definitely assume. It's not the same for all companies. Would not necessarily want the same system, and that there are flaws in our system. So I think, certainly what's gone on in the international capital markets since the passage of Sarbanes-Oxley has been a very rude awakening for New York City. Okay, for those of you who believe that Sarbanes-Oxley has helped our capital markets, imagine how bad a shape the New York Stock Exchanges would be in if we had to pass Sarbanes-Oxley. I'm saying that tongue in cheek. I think it's hurt them. Okay, The other point about American corporate governance in general and how good it was, you and I have both written on takeovers and the threat of the market for corporate control and the incentives that it gives managers. And basically, a lot of our good features of our corporate governance system have been regulated out of there. The hostile tender offer was shut down in the late 80s by a lot of state laws that were passed that have interfered with the functioning of that market. We have a lot of regulation and so forth. But even, I guess going back to, I'm thinking, 1993, Michael Jensen wrote an article in Harvard Business Review entitled "The Eclipse of the Modern Corporation." And he predicted at that time what we have today with the private equity coming in and taking a lot of companies out of the public market. And he made estimates that managers of large publicly traded companies with a few shareholders could waste up to 50% of the equity of the company before it would trigger a takeover or some other type of control change mechanism in the company. And so I do not think the system's been perfect. I agree with Michael Jensen on that. I don't think the system is perfect at all. I think it's far from it. I think we're not taking advantage of market forces the way we could in a lot of instances. The Nirvana fallacy is always compared to what? And that's really another way of saying what we're talking about there. And I've got a whole list of reforms that I would like to have, most of which involve getting the government out of the way of allowing markets to work a little bit better. There's simple things that the government tries to do to make markets work better that become bureaucratic nightmares. It would seem that disclosure of executive compensation, like my former Congressman Christopher Cox is doing, would be something very easy. But the devil is in the details, and those regs go into hundreds of pages now in terms of what's dealing with that, and we've got political battles about whether certain companies are going to have to comply with all aspects of that. It's a mess, And does that mean it's not worth trying? I think disclosure of corporate salaries is a very good thing. I wish corporations would do it voluntarily. Perhaps if there were more market pressures on them, they would do it. So I think I agree, actually, with everything that you were saying, and I didn't mean to imply that I thought we had a perfect system. We had a pretty good mousetrap. Would you please identify yourself?
Dr. Butler, I'd like to ask you, and just sort of as an add-on to this, and I'll just throw this out first to see if you agree on it, and then what might be due for it. I believe one of the consequences of Sarbanes is, as Henry pointed out earlier, that markets and corporations have seen some of the problems, starting with cost. Governance is a hard thing to do, and I wish that maybe Henry would talk a little bit about the megacorporation and the difficulties that someone like Jeffrey Einhoff might have at GE certify 5 separate divisions of one of the largest corporations in the world. That's an impossible task for one man to say. These are in place, and I can certify that we put the right issues on the table, we test for them properly. I run a small business in Rocky River, Ohio, and I happen to be a member of the New York Stock Exchange. It's very difficult for me to do those things with a staff of 14 people. Here's GE, is a $325 billion company, and one person to certify those divisions, it's just asking a lot. Henry and I have known each other for a long time, and he and I know that we're diametrically opposed on most issues. This is a fun note, that we have some agreement. I'm a believer in most of sex, by the way, but I think one of the ramifications that's occurred from this, and it's obvious, exchanges, for example, are consolidating across the world. Why are they doing it? They're doing it because it's easier for companies to list in Europe and Japan and China. And they don't want to give up that market share, so they're finding ways to consolidate, to recapture those listings. Now my question. Since we don't think, and I think we'll agree that SOX isn't going away in its entirety, as we might like it, what can we do? I guess starting with the provision 404, should we eliminate it? Can we somehow amend it? Or just get rid of it entirely? And that's one of the provisions that's really causing business to, in my opinion, to move away from the overseas.
Well, thanks for the speech, Tim. We actually went to junior high school. The 404 is an interesting area because it's very different than what we have in corporate law, which is in corporate law, the adequacy of decisions made by the board is judged by the business judgment rule, whereas there's no judgment involved in Section 404 right now. Basically, the auditors come in and tell you this is the way you have to do it, and you're not basically, I mean, most executives are afraid to even second guess them on anything. So we've got a very kind of rigid system that's put in there. What to do about it within the framework, I think, yeah, if we could have some type of business judgment rule, analysis of controls where the adequacy is based on a trade-off of kind of the cost and benefits, a reasonable analysis of the cost and benefits before anything has gone wrong. All right? With recognition that occasionally, hey, controls may not have been totally accurate. Things, accidents may happen. That would be a better recognition of what's going on as opposed to the very kind of command and control type of system that we seem to have right now. How you would implement that? We got state courts that judges have been very good at implementing the business judgment rule over the years, but this is all going to be in federal court. We could have, but that's the type of, I think, a reasonable trade-off of cost and benefits that we could have reflected in that. Somehow to get to that point. Yes, sir.
Well, you didn't mention anything about Arthur Anderson, and the problem with that kind of going to SOX is the evolution of Arthur Anderson. So we cannot trust the auditors. And one of the benefits of SOX is the creation of the PCAOB, which is auditing, keeping an eye on big auditing things. So we cannot trust the auditors. And that's one of the problems.
Well,
the opportunity to make judgment in the data.
Well, there are a couple of big lessons that came out of Enron, okay? And one, by the way, as future investors, don't put all your eggs in one basket. Right? I mean, for those employees, it's a terrible personal tragedy for many of them, but they did not diversify. So, learn that lesson, okay? They were also perfect people to use as props for intervention in the market. Although they, from a purely financial point of view, hate to be crass, but they were stupid. Okay, that's one thing. Arthur Anderson. Let me see. Do you think the other accounting firms have learned anything from that? Seriously, I'm talking markets here. I'm talking people's wealth, the people who had partnerships in Arthur Anderson that were worth millions of dollars for some of these folks. Okay, well, gone, evaporated as a result of that. The other accounting firms they're part of the problem right now, frankly, but they're taking care of their own internal controls. And I think that they would correct a lot of this stuff absolutely on their own. Another point about Arthur Anderson is we've got a really kind of incredibly concentrated, at least at the upper end of the large firms accounting industry right now. And we've got ourselves in a situation where the federal government is making, when they were making a decision about whether or not to indict KPMG with these tax deals that they were putting together, They basically were engaged in a form of industrial planning, trying to determine what the accounting market is going to look like, was guiding whether or not they made a decision at that level. We've got big problems, I think, in the accounting industry, but a lot of them are incentives of firms in the accounting industry to work out a lot of that. I'm not sure if another government agency is necessary to solve this problem. It surely is an unusual beast that was created there, right? Who pays for peekaboo? Shareholders, right? Okay. Who pays? Who's benefiting from peekaboo? The accounting industry. Okay. So they pulled off a deal where they now, because they screwed up, they get to get someone else to pay for an agency that's going to protect them and increase the demand for their services. I mean, we could have this view that, boy, it's a wonderful, good thing, but there are a lot of other issues that are going on there. I mean, the accounting industry, which a lot of people say deserves to be blamed for what happened with Enron and WorldCom, they're the ones that have come out smelling like roses, right? Demand for their services. Auditors are now the beautiful people. That's scary. I mean, come on. I mean, smart people are getting bid into those jobs. No,
By the way, I'm an accounting doctoral student. So I'm one of those who's benefiting.
You're here as a representative of the cartel, right? You first.
So you mentioned a lot about the executive incentives, especially when you're dealing with. You mentioned the executive incentives, especially as you're dealing with civil and criminal litigation, not being the solution when we're dealing with. And I'm sorry for using these terms, optimizing the level of fraud. What do you see as the ideal way to get the agency problem taken care of here, to get the board of directors and to get the CEOs of companies operating along the lines of the shareholders as we see? Is it purely a free market solution here?
Well, I mean, the tradition that I write in corporate law was a contractarian view of the corporation, where, I mean, just to take you to the very basic things, the corporations are, I don't know, in some of your corporations class you taught they're created by the state when you go get a charter, but I view that as more of a birth certificate, right? And the state does not create the child when you get the birth certificate. It's entrepreneurs that come together and they have an idea, they have a business, they have contracts about their relationship, and then they get their charter from the state. And a lot of what we see in corporate law and the rules of corporate law are things that would be default rules that parties would negotiate for if they were starting from scratch. All right, so I view it as very much of a contractual, market-oriented environment that we're in anyway. Corporate laws are very enabling, that they allow, and for many instances where you can contract out of whatever the rule is. So there are very few kind of rules that you absolutely have to apply with. So to some extent, we have that market right now. That's what I would call a market. It's a contractual environment. We've seen over time lots of people being in favor of rules requiring independent boards. But we've also seen, in spite of those rules not being, before those rules were being adopted, evolution towards boards being more independent because of a determination that that can add value to the company. But in a market-oriented world, how many independent people do you want on your board? As long as the marginal benefit is greater than the marginal cost. And that's how markets work. Now, if someone in Washington determines that for this particular board, it's for every board it needs to be 50%, then I think there are going to be a lot of mistakes out there. Some boards that may be less, some boards that may be more, based on the ownership structure of the company, based on how competitive their product markets are. So there are a lot of different things that can go in there. There are a lot of market pressures that come to bear on people who serve on corporate boards, that their reputations are real important to them. And I mean, they rarely have to pay any money out of their pocket when they get sued. They're indemnified. All right, but their reputational effect is huge, and they may not be invited to serve on other boards as a consequence of that. I view all of these things as market pressures that bring a lot to bear on forcing managers to act in the shareholders' best interest. That said, it is not a perfect system. And to George's point, about CEO dominance, I think, is one that is a real concern. If you go into large corporations, they talk about the CEO like he or she is God, okay? And, you know, it's come from on high. And there's a lot of deference, and they're allowed to do a lot of things, and to make a lot of mistakes, honest mistakes, before people will second guess them. And so there's a lot of those issues there. Competitive markets are a source of this. And just to give you an example, the best thing that I think ever happened to the American economy in the last quarter of the century was the dramatic increase in foreign competition of development of international markets, automobiles, steel, electronics, that whole area woke up American businesses like they'd never had to before. And then Michael Milken and the invention of the junk bond scared the heck out of corporations who didn't think they ever had to be worried about being taken over. And now how do we take over corporations? We got the private equity, which is a great thing. It's coming through, and it's changing the monitoring of mechanism of corporate boards when the markets are not working effectively, or the cost of the markets are too high. Okay.
I'm just curious about the Enron thing. The people that lost the benefits when Enron folded, were they stupid because they didn't diversify, or did they really have an option to diversify?
I can't recall the exact rules of what their portfolio. I thought they had an option after a time to yeah, they could diversify.
I mean, it seems like from what I heard, they were forced to accept de facto IOUs rather than get their benefits right away, so that they could invest it however they wish to invest it.
Well, there may have been a culture that you were a disloyal citizen if you employee if you diversified your stock, but I don't know what else to add to that.
I mean, this seems like a conservative libertarian position that a person could take, that the employees of Enron should have gotten their money up front, so that they would have the choice to invest it however they chose to.
None of them were slaves. They could have gone to work somewhere else. I mean, you know, it's if you want to market, that's the market. They thought they were getting a good deal. They took a risky position, and a lot of them lost a lot of what they thought they had. Not to the sense that the stock was inflated because of fraud. Maybe they never had as much as they thought they had anyway. But I don't know how else to respond to that.
Any probably time for one more question? If there is one more question. Okay. And if not, then thank you very much. And